I want to tell you about a document that arrived on a gun shop owner's desk in Tucson, Arizona. His name is Vincent. He has operated his federally licensed firearms dealership for 19 years. During those 19 years, Vincent has run a spotless operation, background checks completed on every single transaction, paperwork submitted accurately, no violations, no complaints. The kind of gun shop owner who represents the backbone of responsible firearms retail across this country. 2 years ago, Vincent received a legal notice informing him that he had been named as a defendant in a civil lawsuit, not because of anything he personally did incorrectly, not because he sold a firearm unlawfully, not because he failed to follow a single federal regulation, but because a firearm he had legally sold through the proper legal process was later used in a crime by the individual who purchased it. Vincent contacted me the same day that notice arrived. He was not panicked. He was something quieter than panic, a kind of worn-out disbelief. He said, "I did everything correctly. I ran the background check. I submitted the paperwork. The government approved the sale. How am I sitting here reading through a lawsuit?" I told Vincent what I am going to tell you in this video. The answer to his question, how a federally licensed dealer who followed every regulation can still be pulled into court over a lawful sale, is the precise legal question that just went before the Supreme Court of the United States. 9 justices, 0 dissents. A unanimous decision that addressed the most significant legal protection standing between gun manufacturers, licensed dealers, and the wave of litigation that has been specifically engineered to financially destroy the firearms industry one lawsuit at a time. The case is called Smith & Wesson Brands versus Estados Unidos Mexicanos. The nation of Mexico brought it, and the Supreme Court just stated in the clearest possible terms, with 0 disagreement among 9 justices, no, you cannot do this. In this video, I am breaking down precisely what the ruling says, what the PLCAA is, and why it exists, what this ruling means specifically for you as a gun owner, and the 3 things about this decision that most of the media coverage has completely overlooked. Stay with me. This one carries more practical impact on your rights than most people realize. Before I walk you through the ruling itself, I need to give you the complete context of what this case was genuinely about. Because framing this lawsuit as simply Mexico versus gun manufacturers misses the deeper legal strategy that this case actually represents. Here is what has been unfolding in American gun litigation for the past 25 years. Gun control advocates who have been unable to accomplish their policy objectives through legislation, through Congress, through state legislatures, through democratic processes, have pursued an alternative strategy. That strategy is litigation, specifically filing massive civil lawsuits against firearms manufacturers and licensed dealers. Not to prevail in those lawsuits on their merits, but to impose legal defense costs so staggering that the targeted companies and dealers are either financially destroyed by defense expenses alone or compelled to settle on terms that effectively regulate their conduct without any legislative action ever taking place. This approach is sometimes referred to as regulation through litigation. And in the late 1990s and early 2000s, it was working. Dozens of municipalities filed lawsuits against gun manufacturers. The costs of defending those suits were enormous. The firearms industry was confronting an existential financial threat, not from any law passed by any legislature, but from civil litigation specifically constructed to be too expensive to contest. Congress responded in 2005 with the Protection of Lawful Commerce in Arms Act, the PLCAA. The law established a specific legal protection, a federal immunity from civil liability for manufacturers and licensed dealers when their products are used criminally by a third party following a lawful sale. The logic underlying the PLCAA mirrors the same logic that shields car manufacturers from being sued when someone uses their legally purchased vehicle to commit a crime. The same reasoning that protects knife manufacturers when a knife is used as a weapon. You cannot hold the manufacturer of a legal product responsible for the independent criminal act of the person who purchased that product when the sale was lawful and the manufacturer did nothing wrong. But here is the part that matters most for this video, and the part that the Mexico lawsuit was specifically engineered to exploit. The PLCAA has exceptions. It is not absolute immunity. There are specific circumstances under which a manufacturer or dealer can be sued despite the PLCAA's protections. And one of those exceptions, called the predicate exception, has been the focus of increasingly inventive legal arguments by plaintiffs who want to circumvent the PLCAA's protections. The predicate exception states that a manufacturer or dealer can be sued if they violated a statute specifically applicable to the sale or marketing of firearms, and that violation was a proximate cause of the harm alleged. Mexico's entire legal theory was constructed around an argument about how the predicate exception applies to their claims, and the Supreme Court just addressed that argument head-on. If you want every Second Amendment and firearms law development broken down the moment it matters, hit subscribe right now, because this ruling carries implications that extend well beyond the headline. Now let us get into what the court actually decided. Section 1. What the PLCAA actually says and why it matters. Let me begin with the foundation, because you cannot understand the ruling without first understanding the law it was interpreting. The Protection of Lawful Commerce in Arms Act, passed by Congress in 2005, establishes a specific federal immunity for firearms manufacturers and licensed dealers. Under the PLCAA, a qualified civil liability action, meaning a lawsuit against a manufacturer or dealer for damages resulting from the criminal or unlawful misuse of a firearm, is prohibited and must be immediately dismissed. The law applies to both manufacturers and to federally licensed dealers, and this is the portion that matters directly for gun owners, because it means the stores where you legally purchase your firearms and the manufacturers whose products you depend on are shielded from being financially destroyed by litigation over sales that complied with every federal requirement. Why does this matter to you as an individual gun owner? Because the alternative, a legal landscape without PLCAA protection, is one in which every licensed dealer faces potentially unlimited civil liability for any lawful sale that is later misused. In that environment, the rational response for a dealer is either to stop selling firearms entirely or to impose restrictions on sales that go far beyond what federal law actually requires. Restrictions driven not by law but by litigation risk management. The PLCAA is, in a very direct sense, the law that keeps your neighborhood gun store open and prevents the prices of legally purchased firearms from being driven upward by litigation insurance costs passed along to consumers. When the PLCAA is under attack, your access to legal firearms commerce is under attack, even if you personally are never a party to any lawsuit. Section 2. What Mexico argued and why the court said no. Here is the specific legal argument Mexico presented and why the Supreme Court rejected it 9-0. Mexico's lawsuit against American firearms manufacturers alleged that the manufacturers were aware their firearms were being trafficked across the border into Mexico and used by drug cartels, and that the manufacturers' marketing and distribution practices contributed to that trafficking. Mexico sought billions of dollars in damages. The manufacturers argued that the PLCAA barred the lawsuit entirely. Mexico contended that the predicate exception applied, specifically arguing that the manufacturers had violated state law statutes applicable to firearm sales and that those violations were a proximate cause of the harm Mexico suffered? Here is the central legal question the Supreme Court was required to answer. The predicate exception permits suits when a manufacturer or dealer knowingly violated a state or federal statute applicable to the sale or marketing of firearms. Mexico argued that certain state law statutes of general applicability, laws that apply to all businesses, not specifically to firearms businesses, counted as statutes applicable to the sale or marketing of firearms for purposes of the predicate exception. The Supreme Court rejected this argument unanimously. The court held that the predicate exception requires a statute specifically applicable to firearm sales or marketing, not a general business law that simply happens to apply to firearm sellers alongside every other business operating in that state. This distinction between a firearm-specific statute and a general statute that merely reaches firearm sellers is the heart of the ruling, and it matters enormously because Mexico's entire theory, and the theories of many domestic plaintiffs who have attempted similar arguments, depends on using general state laws to sidestep the PLCAA's protections. The Supreme Court has now closed that door. All 9 justices agreed. There was no dissent, no partial concurrence carving out a different approach. 9 justices spanning the ideological spectrum of the court agreed that the predicate exception means what it says, and what it says requires a firearm-specific statute, not a general one. Section 3, the 3 things the coverage missed. Now let me walk you through 3 specific implications of this ruling that most of the media coverage has either understated or missed entirely, because these are the things that carry the most practical significance for gun owners. Thing 1. The ruling closes a specific and widely used litigation strategy. The argument Mexico made, using general state statutes to trigger the predicate exception, was not unique to Mexico. Domestic plaintiffs in multiple states have advanced similar arguments in cases against both manufacturers and dealers. The unanimous character of this ruling sends a clear signal to every court across the country about how the predicate exception must be interpreted. This means that lawsuits currently pending against firearms manufacturers and dealers that rely on the same general statute theory now face a considerably more difficult path forward. Defendants in those cases will cite this ruling. Courts will apply it. Some of those cases will be dismissed on precisely this basis. For gun owners, this means the industry you depend on for legal access to firearms is more legally secure today than it was before this ruling came down. Manufacturers facing existential litigation costs over lawful sales are protected. Dealers like Vincent, who operated clean businesses, are protected. Thing 2. The ruling does not change what you can and cannot do. I want to be precise about this because I have encountered coverage of this ruling that implies it somehow expands individual gun owner rights in terms of what you can legally carry, where you can carry, or which firearms are available to you. It does not. This ruling addresses civil liability for manufacturers and dealers, not individual rights under the Second Amendment. Your carry rights, your purchase rights, the specific firearms available to you under federal and state law, none of that is directly affected by this ruling. The ruling shapes the legal framework within which the industry operates, not the specific legal rights of individual gun owners under the Second Amendment. If you have encountered content claiming this ruling means you can now carry anywhere, that assault weapons bans have been invalidated, or that any other specific individual right has expanded, that content is incorrect. This ruling does not say those things. Anyone telling you it does is either confused about what the case actually decided or being deliberately misleading. Thing 3. The predicate exception still exists and still carries real force. The ruling did not eliminate the predicate exception to the PLCAA. It clarified which statutes can qualify as predicates. The exception for actual violations of firearm-specific statutes remains fully intact. This means that a dealer who genuinely violates a firearm-specific law, a dealer who knowingly sells to a prohibited person, a dealer who fails to conduct required background checks, a manufacturer who markets products in ways that specifically violate state firearms marketing statutes can still be sued under the predicate exception. For honest, law-abiding dealers and manufacturers, this is not a concern. For dealers operating outside the boundaries of the law, the predicate exception still reaches them. The ruling protects lawful commerce. It does not extend protection to unlawful commerce. Vincent's situation from our opening is directly addressed by this ruling. A dealer who completed every background check, filed every required form, and processed every lawful sale is precisely the kind of operation the PLCAA was designed to protect, and that this ruling has confirmed remains protected. Section 4. What this means for the future of gun litigation. Let me place this ruling within the broader context of where Second Amendment and gun-related litigation is heading, because understanding the trajectory matters for gun owners who want to know what comes next. The PLCAA has been under sustained legal attack since the moment it was enacted. This ruling represents a significant and unanimous reinforcement of the law's core protection, but it is not the conclusion of the legal effort to use civil litigation as a policy instrument around gun laws. Here is what to watch for. The plaintiffs' bar, the attorneys who file these cases, will now redirect their focus toward identifying statutes that do qualify as firearms specific for predicate exception purposes under the ruling's framework. The question is no longer whether general statutes work. The court said no. The question now becomes which specific firearm statutes in each state can serve as predicates. This means that state-level legislative activity surrounding firearm-specific marketing and sales statutes is going to intensify. Attorneys who wish to bring PLCAA predicate exception cases need firearm-specific statutes to work with. In states where those statutes are limited, expect legislative pushes to create them specifically for use as litigation predicates. For gun owners residing in states with active gun control legislative agendas, California, New York, New Jersey, Illinois, and comparable states, this means paying close attention to which firearm-specific statutes are being proposed and enacted at the state level, not only for their direct regulatory impact on gun owners, but for their secondary function as potential PLCAA predicate exception vehicles. Section 5. The practical action steps for gun owners right now. Let me close the legal breakdown with what this ruling means for you in practical terms, specifically what you should understand and what you should do. First, know that your legal purchases are protected. A firearm you legally purchased from a federally licensed dealer who followed all applicable federal requirements is a product that came through a legally protected transaction. This ruling reinforces that protection. The manufacturer who produced it and the dealer who sold it are not going to be driven out of the market by litigation over lawful sales, which means your continued access to those products and those dealers is more stable than it was before. Second, know which dealers you are purchasing from. The PLCAA protects compliant dealers. It does not protect dealers who cut corners, who skip background checks, who falsify records, or who knowingly sell to prohibited persons. The predicate exception still reaches bad actors. Purchasing from licensed dealers with clean compliance histories is not simply about your own legal protection. It is about buying from dealers whose legal protection is also well established under this ruling. Third, understand that individual rights litigation is a separate matter. This ruling does not resolve the assault weapons ban question. It does not resolve the carry rights question. It does not answer any of the pending questions about which specific firearms and accessories are protected under the Second Amendment. Those cases are advancing through the courts on separate tracks. tracks we have covered in other videos on this channel. Do not conflate this ruling with those questions. They are legally distinct. Fourth, be skeptical of content claiming this ruling accomplishes more than it actually does. This is genuinely important. There is a considerable volume of content circulating online right now claiming this ruling dramatically expanded individual gun rights in ways it simply did not. Accepting that content and acting on it can place you in legal jeopardy because the individual rights questions that content claims are resolved by this ruling are not resolved. The laws those content creators are claiming have been invalidated remain in full effect. If you ever come across a piece of gun law content that sounds too good to be true, that claims some sweeping ruling just eliminated all carry restrictions or struck down all magazine limits, take 30 seconds and search for the actual case name. If you cannot locate it on SCOTUS blog or a credible legal news outlet, it almost certainly is not what it claims to be. Let me bring everything together one final time. The PLCAA, the Protection of Lawful Commerce in Arms Act, is the federal law that shields firearms manufacturers and licensed dealers from civil liability for the criminal misuse of legally sold firearms. The Supreme Court's 9-0 ruling in Smith & Wesson versus Estados Unidos Mexicanos upheld the PLCAA's protection and specifically held that the predicate exception requires a firearms-specific statute, not a general business law, to override that protection. Three things the coverage missed. This ruling closes a widely deployed litigation strategy. It does not directly expand individual Second Amendment rights, and the predicate exception still carries real force for dealers who genuinely violate firearm-specific laws. The future to watch. State legislatures in gun control states will pursue new firearms-specific statutes crafted specifically as PLCAA predicate exception vehicles. That is where the litigation strategy moves next. And for you as a gun owner, your access to legal firearms commerce is more secure today than it was before this ruling. The manufacturers and dealers who form the backbone of the legal firearms market are better shielded from the specific litigation strategy this case embodied. Vincent made it through his situation because the PLCAA did exactly what it was designed to do, and because this ruling confirmed it will continue doing so. He called me after the decision came down and said, "Finally, 9 people in Washington understood what it means to do everything right and still need protection from a lawsuit." 9 people. 0 dissents. Share this with every gun owner you know who has been hearing about this ruling, but has not received a clear, accurate explanation of what it genuinely means. Because accurate information about what the law actually says is the only thing that keeps gun owners on the right side of it. What is the next major gun rights case actually moving through the courts right now that could directly affect which firearms and accessories you can legally own? Check out the next video where I break down the current Supreme Court pipeline, the specific cases, the specific legal questions, and the realistic timeline to a decision. I will see you over